Let us continue with part 18 and part 19. We studied up to part 17, official language, part 17 of the Indian Constitution yesterday. Now we shall move on to part 18 and part 19 of the Indian Constitution. Okay, part 18 and part 19. Part 18 will contain the emergency provisions, and part 19 will contain the miscellaneous. Okay, those which they miss out on. Those which they forgot to add in the Indian Constitution, or miscellaneous is almost like the 12th schedule that we have, right? 12th schedule was added at the back of the Indian Constitution, before the article before the anai, and then miscellaneous be the chutu mudu na side te kute thalio kute natala najanele or nadun chapter the miscellaneous grade policy edi before the ani dise. Okay, that's just plain simple. That's just a plain simple reason for why they created the miscellaneous section. Now, this is the constitutional framework. Part 18 will cover articles 352 to 360. 352 being national emergency, 356 being state emergency or president's rule, 360 being financial rule. Okay, and part 19 will cover articles 361 to 367, miscellaneous. Okay. Now, let's begin with part 18, emergency provisions, article 352 to article 365. Now, 360, sorry. Emergency provisions enable the union government to deal with extraordinary situations that threaten national security, constitutional governance, financial stability. Now, national security garne, national emergency for constitutional governance to maintain the constitutional status in case of failure of constitutional machinery in the states, state president's rule. Okay, state emergency is called president's rule, and then financial stability. For financial stability, we have the third one, financial emergency. While ensuring that democratic institutions continue to function under constitutional safeguards. Okay, so we have the national emergency, we have the state emergency, president's rule, and we have the financial emergency. Okay, we do not call it state emergency, we call it president's rule. Okay, technically, in the Indian Constitution, president's rule is mentioned. It's not a state emergency. It only mentions failure of constitutional machinery in the states, and as a result of which the president comes over and takes over the state executive. We will learn in detail. Emergency 352, failure of constitutional machinery in the state. 356, financial crisis, financial emergency, article 360. These three articles are very common articles, and it's something that you cannot let go of. Okay, you have to know that. Dimak pitore thai kiwale lage. Ito do opay na ide. Ito najin na ina like that. So these three emergencies differ in the grounds, procedure, effects, and constitutional consequences, which we will learn about in the following slides. Okay. Now these are emergency provisions at a glance. National emergency, threat to the nation. Again, president's rule, failure of constitutional machinery in the state. Financial emergency, threat to India's financial stability. Now, we have never ever had financial emergency till today. So remember that as well. Each emergency has a different constitutional purpose. Now, we have had national emergency 3 times. Okay. Each emergency has a different constitutional purpose, which we will learn about in the following slides. Now, look at Article 352, the first article of Part 18 of the Indian Constitution. Article 352 empowers the President of India to proclaim a national emergency when the security of India or any part of its territory is threatened. The President of India to proclaim a national emergency. But who is the one with the actual power? The Prime Minister and the Council of Ministers. Okay. Grounds for proclamation: war, very important terms: war, external aggression, armed rebellion. Okay, very important that originally the Constitution used the term internal disturbance instead of armed rebellion. Armed rebellion nathakigina internal disturbance thakise. Now in the year 1975, who was the Prime Minister of India? Indira Gandhi. To Indira Gandhi la time te the Supreme Court pointed out the election malpractices of the Prime Minister, and so at the time they using the internal disturbance la people were protesting against her. So using that as a source, as a reason, she declared national emergency. Okay, she was the one who declared national emergency because of internal disturbance. So itia to kushi national emergency call na dio karne internal disturbance was replaced by armed rebellion. Armed means it needs banduk khan ki khan all of bishi serious hole egla national emergency declare global. Okay, Modi ji cannot just declare national emergency kushi. Now internal disturbance karne kitte bhi national emergency create karna bro, just armed rebellion. For example, maybe Naga Manugan insurgencies kan underground kan banduk kan karna India pura de China mara national emergency declare hoga. Bole khali like without any kind of arms, just verbally protest court haga dido, ye dido emergency na hobo. Okay, that was a clarification made by the Supreme Court in the 1978. Before that, and then the 44th Constitutional Amendment 1978 replaced it with armed rebellion to prevent the misuse. Okay, so 352 national emergency. The grounds for proclamation: war, external aggression, and armed rebellion. Okay, these are the 2 points, and the third point that you need to know about 352 is the 44th Constitutional Amendment Act 1978 replaced it with armed rebellion. Okay, so these are the 3 points that you need to understand. Replace internal disturbance with armed rebellion. Okay. Now this is the simple procedure for your understanding. Okay, for your understanding, you don't need to memorize it for your exam. For your understanding, the Union Cabinet sends a written recommendation to the President. Modi ji and his Council of Ministers will send a written recommendation to the President, and then the President will issue the proclamation, the national emergency. Step 3, both houses of the Parliament must approve within 1 month by a special majority. Okay, President national emergency proclaim it stays on forever. No, it must be approved by both houses of the Parliament within 1 month by a special majority. What is special majority? 2/3 of the members present and voting, and then 2/3 of the members present and voting, and then majority of the total membership of the House, 50%. So by a special majority, both houses must approve within 1 month. Step 4, if approved, emergency continues for 6 months. 6 months karne aro continue gurode. Once approved by the Parliament, Lok Sabha and the Rajya Sabha approved Purishi Guledo, it will continue for 6 months and maybe extended every 6 months with parliamentary approval. So every time 6 months extend Gurigana Jabo. And one very important note is that there's no maximum period up to which emergency will go on. National emergency could go on for 100 years. The Constitution gives them the power to do that. There's no time limit. Okay. Whereas state emergency, or what we call President's rule, maximum 3 years as a. Ito ang janyo lagi differences kan. Okay. Last table like tapal banay na se. To ye table apni kan direct screenshot ko na puri lugi. Now Article 352, parliamentary approval. Majority, special majority la mentioned kurigana se. The one that I just mentioned now. Majority of total membership of each house, Rajya Sabha and Lok Sabha, and not less than 2/3 of members present and voting. Okay. So it needs the approval of the Lok Sabha and the Rajya Sabha. So this constitutional safeguard, it was introduced by the 44th Constitutional Amendment Act 1978 to strengthen parliamentary control over emergency powers. Now, exam tip, 38, 42nd, and 48 constitutional amendments are the most important amendments. Okay, if you guys want to write it down, you can write it down. 38, 42nd, and then 44. It's a these are the 3 amendments that you can research on. Okay, research on. I will just be explaining in brief. 38, 42nd, and 44th amendments related to emergency provisions. These are the 3 constitutional amendments that are important. Now, duration and extension and revocation of national emergency. Duration 6 months, I've mentioned earlier. After parliamentary approval, and it could go on for as many 6 months as possible. Extension, it may be extended every 6 months by Parliament through a special majority. And revocation, okay, how to cancel national emergency. The President may revoke the emergency at any time by issuing another proclamation. Okay, by issuing another proclamation. The special safeguard, if at least 1/10 of the total members of the Lok Sabha give a written notice, 1/10. Now, for cancelling emergency, Rajya Sabha lahat the power nine. Just the Lok Sabha, okay. For cancelling the emergency, Rajya Sabha doesn't have the power. It is only the Lok Sabha. If at least 1/10 of the total members of the Lok Sabha, right now we have 543 members in the Lok Sabha, so 54.3, let's say. Let's just take 55. 55 Lok Sabha members can written notice delay though. A special sitting must be convened, okay? And then the Lok Sabha may revoke the emergency by passing a simple majority resolution. Now, majority of the members present and voting, simple majority. Simple majority bro. Lok Sabha bro, the emergency, national emergency though, cancel bro. But one very important point to note, okay? It is only the President, officially it is only the President, nah? But in reality, the President is obligated to listen to the decision made by the Lok Sabha to cancel the national emergency, and he will declare another proclamation of the cancellation of national emergency. Okay, so it gives power. Why does it only give power to the Lok Sabha? Because when it comes to national emergency, we're talking about the welfare of the people, the public, and it is the Lok Sabha members that are representatives of the people. Like I said, here in Nagaland, Rajya Sabha, we have Pangnon, right? Pangnon was chosen by the MLAs, but Supangmaran was chosen by the people. And that is why only the Lok Sabha is given the power to cancel, okay, the emergency. Now, Article 353, effect of national emergency. Once a national emergency is proclaimed, executive power of the union extends to giving directions to any state. Now, executive power, pull out the executive power as a state then. Council of Ministers, right? Rio and his Council of Ministers, utun nahaday de. Utun nahaday. State emergency dito, hatay de. Again, President's rule na, state emergency dito, hatay de. But, national emergency dito, nahatay, but, union brought directions dito pare. Okay? Union can brought directions dito pare. Utu kurbi bole, they have to do it. If Nagaland's budget, if the overall money we have in our treasury is 4,000 crore, let's say, and then we were planning to, give grants to various departments, 100 crores, 50 crores, and so forth. But if they say you need to spend 2,000 crores on procurement of arms and ammunition because we're fighting against China, then the state executive needs to listen. Inalize emergency time dito upay na. And legislative powers, again, state list legislate korle, laws panawale. Dadebi kuniwa lagi kota center laga. And federal structure, the constitution temporarily, just for temporary, okay, not permanently, it becomes more unitary. The center has more control over the states at times of emergency. The state governments continue to function unless President's rule is separately imposed under Article 356. Okay, 356 means state emergency, President's rule. Udu noatak to state government though, it continues to function. Got it? And that's 354. Now, during a national emergency, the President may modify the constitutional provisions relating to the distribution of financial resources between the Union and states. Again, here, constitutional provision there, financial distribution. Right now, what do we have in the share of central taxes? What's the percentage in the divisible pool? All the taxes collected by the center, 41% is given to the states, given back to the states, and then 59% is retained by the center. Now, this rule could also change, and other types of financial rules in which the financial resources between the union and the states are done. Okay, so whereas financial rules, whatever is present right now, it could change at times of national emergency. Now, I think that's understandable. So, distribution of revenues during emergency, purpose to meet extraordinary national expenditure. Let's say we're having a war with China. We would need a lot of missiles. We would need a lot of aircrafts. We would need a lot of arms and ammunition. We would need submarines. We would need fighter jets. it would need a lot of weapons. We would need a lot of surveillance, tanks, everything. Pusabra luido. So in that time dedo, union la hate control bishik hake. Okay. But any such presidential order in which the resources, the sharing of money between the union and state is to be changed. Utu order though it must be laid before the parliament. Parliament के reason दिवो लगे. Okay. Article 355. Duty of the union to protect states. Article 355 simply says that it is the duty of the union to protect the states whenever the state is in danger. For example, if China attacks Nagaland today, it is the duty of the union to protect Nagaland. Itu ko ase Article 355 dito. Protect every state against external aggression and internal disturbance. Internal disturbance to yedi ki ase insurgency as well. So using Article 355, they also invoke the XVIII Act. Okay, XVIII Act to be yedi link ekta. They feel like it is their duty to protect us against internal disturbance, against the undergrounds. Union duty of the union. So constitution you have to protect your respective states. Ensure that the government of every state is carried on in accordance with the constitution. Now, Article 355 is not an emergency provision by itself. Okay, not an emergency provision. Like I said, only Article 352, national emergency, 356, state emergency or president's rule, and 360, financial emergency. Now, Article 355 is not an emergency by itself. Instead, it provides the constitutional basis for union intervention in the form of, let's say, and supports the use of president's rule, state emergency, Article 356, where necessary. Okay, to utubra ekta reason de president's rule kan ayo di bole na, like the case of Manipur, recent, and in Nagaland we had it in the year 2008, I think, the latest 2008, and then utu Rio la government tagishe majority la problem tagishe constitutional failure of constitutional machinery in the state because the majority do proof koro paranai. Okay, and then we also had the same similar case in the 1990s, around 1992, XVIII's government la time de. But before that, in the 1998 and 1978, utu do underground la issue karne thagishe. Moala state emergency. President ba direct rule grado na. Utu ase. Longest period to 1975 to 1977 or 78. Okay, I don't remember. Utu tik utu Shillong Accord time de Shillong Accord sign gushe na. Our NNC kan they accepted the Constitution of India, and they also accepted that their arms to be deposited, and they accepted that further time to be given for rehabilitation of the NNC workers. So utu tinda point agreement accept kora bishide muiva ro isak chishido pia baishido. In 1980 de NACN form gushido. In 1988 de NACN IM to NACN K separate gushido. I think Sir Rodsu mentioned that. Na so utu time in 1975 de Shillong Accord sign gradam de manu bishi against like kili India lo sign greze. Wena chamlo uladam de utu time de president's rule ala. Okay, and also in 1988 when NACN split into NACN IM and NACN K kaplang, and then isak muiva utu time de bi chamla bishi thagise underground la the president's rule thagise, and then AC chamler do utu time de do aro state level legislative assembly la problem, and 2008 to be Rio la time de state legislative assembly la problem. So in all these four cases we can see that there is a failure of constitution, failure of Indian constitution. The rules kan to power chula na pre, which means public kan to power protect kora na pre do. Constitutional rule hisab de do peace guarantee kore, security guarantee kore. It's a failure of constitutional machinery. To utu time de president's rule I work state emergency. Okay. Next is state emergency. So just a background of how emergencies were proclaimed in Nagaland. The president may proclaim president's rule state emergency if the governor reports that the government of the state cannot be carried on according to the constitution, or the president is otherwise satisfied that such a situation exists. Governor recommend grade usually 99%, but president da interview say oh to think na go na bo pare do neutral country ase na utu tuita de but behind the scene kun thakibo council of ministers thakibo center de. So the common grounds, no party has a majority after elections. Udo SC Jammer la aro Rio la then the majority la problem ekta thakise, and then collapse of council of ministers la problem bi ekta ase. To utu time de do constitutional failure ekta thakise. But the 1975 and 1978 de do tahan collapse hola noi, but tahan power na thakala na. Minister ase bolibi public ke protect koro na pare do. So that's a failure of constitutional machinery. Ito kare president's rule aise. 92 or 2008 to Taichen do majority proof correlate dictator hua karne ek par karne president's rule aise. Iman serious thaka nai de 92 or 2008 but oh my goodness 1975 la president's rule da khatarnak thakise. Ini beshi kara thaise aro 88 la bi beshi kara thaise. So we had 4 state emergency here in Nagaland. National emergency 3, financial emergency 0. Okay, don't forget that. So no party, these are the common grounds. And effects of the president's rule, state emergency time there. After the proclamation, the president assumes the executive functions of the state government. Okay. Dismiss kure de council of ministers to Rio khan pura dismiss ho jawo. President but direct rule guru. The governor acts on behalf of the president. The state council of ministers is dismissed. Okay, the state dismiss meaning dissolve to one head. President's rule and obviously they can get back in and then continue with the government. Okay, dismiss a club will say. But again, the state legislative assembly may be suspended or even dissolved. Pura dissolve kuro lebi pare. To central law of body ase. Koina ko ase. The parliament exercises the legislative powers of the state legislature. It's very simple. Whatever powers and functions of the legislative assembly of the state, we know every powers and functions will be held by the parliament. Okay. The High Court continues to function very normally. High Court is the same. Nothing changes about the High Court. High Court will be the same. Okay. Meaning, President's rule ba High Court ke control karo na pare. High Court will continue to stay independent. Now, Article 356, duration. Initially valid for 6 months. Okay, the proclamation of state emergency must be approved by both houses of the parliament within 2 months. National emergency within 1 month as well. State emergency to our national emergency to special majority. Here in the state emergency, simple majority are within 2 months as well. So all of flexibility na. National emergency do bishi dangor case ase do within 1 month approve kor lage parliament ba aro special majority thakibo lage ina noile do president's rule national emergency na thakibo oli bi yeti do simple majority ba hoi jabo na aro 2 moina do dibo kam se kam na ite ekta leniency do thike ase yede. It's initially valid for 6 months. After approval may be extended every 6 months, one maximum period 3 years. Subject to constitutional conditions. What are constitutional conditions? Peace IJL. Nile aro constitutional failure aro 3 years aro natun or another it will be counted as a different emergency. Aro shuru hole chance to ase. But maximum the 3 years to take. An extension beyond 1 year is only possible under the following 2 conditions. Okay, extension beyond 1 year. Article 356. It is possible only if a national emergency is in operation in whole or part of the state. National emergency thagadamde ekla state emergency do beyond 1 year lui jaw parbo, or election commission plus certify that elections cannot be held in that state beyond 1 year. Either of these 2 conditions meet crucially do beyond 1 year lui jaw parbo. Okay. Now slide Article 356. SR Bombay versus Union of India. Please read this. It's related to state emergency. So, Article 356, the SR Bombay versus Union of India 1994, the Supreme Court clarified that the center simply cannot impose president's rule kushi, okay? There are conditions. If the governor feels like the government cannot be formed, right? Nagaland the government form grown up or what? The failure as a, if they cannot form the government, then president's rule automatically aijado. The governor be kushi government the form grown up or ina go na bro de. First though, assembly la floor the test grow lage majority do. Na voting system bra test grow lage ina hoigi na evidence tik tak say that government cannot be formed. Rio CM and his council of ministers cannot be formed. Then only president's rule IV. Okay? Or the president's satisfaction is subject to judicial review. Supreme Court probably review grow lage. It's subject review grow paruo. And Article 356 cannot be used arbitrarily for political purposes. Na political agenda kan karne Modi ra, let's say Congress government as a the Congress government hoa karne the president's rule aniwo. Na uto kan grow na pro ko as a Supreme Court. And if that's the case, then Supreme Court can strike down the president's rule. So uto as a SR Bombay versus Union of India, very important case. Now, Article 357, legislative powers during president's rule. Again, I think I've explained that when the president's rule in force, the parliament exercises the legislative powers of the state legislature. The parliament may authorize the president to make the laws for the state. The president may further delegate this power to another authority. Okay, which means it could be the governor, it could be an administrator, or anyone. Now, after president's rule ends, laws made during president's rule. Let's say President Bra Ekta, imagine that there's president's rule here in Nagaland, okay, from this year, from next month, all the way up till for 1 year, let's say from the month of September 2026 to October 2026. Now, whatever laws made by the president during that time, it continues to be in force unless removed by the state legislature after 1 year. So once state legislature pick, obviously, they can remove it, but it remains in force, okay? President ba key laws can introduce, it remains valid until they are altered, repealed, or amended by the newly elected state legislature. Okay, so its purpose is to ensure the continuity of governance during constitutional breakdown. Article 358, suspension of fundamental rights. Very important point. Okay, you have to know it. Suspension of fundamental rights under Article 19. Article 358 operates only during a national emergency declared on grounds of war or external aggression, not armed rebellion. Okay, armed rebellion no hai, khali war or external aggression, which means basic severe case de ikla. Now Article 19 do suspend gruwa. The freedoms guaranteed under Article 19 are automatically suspended at times of war or external aggression. Okay, not at times of state emergency. Not at times of financial emergency, only at times of national emergency. To be war or external aggression, not armed rebellion, war or external aggression, the Article 19 do suspend gurede. Okay, the state may make laws or take executive actions inconsistent with Article 19. Now, here in this case, the state means everyone, all the government, the state government, the union government, everything, the authorities, they can make laws that is inconsistent with Article 19. What is Article 19? Protection of 6 rights regarding freedom of speech and expression. Now, it could go against our speech and expression. Assembly. Now, they could pass a law in which they'll not allow us to form assemblies. They'll restrict the assemblies of maybe 5 to 6 groups of people. And association. Now, political associations might be restricted. Movement might be restricted. Movement bisi ahaja nogrole for security measures. Residents, kumba jagade residents, kumba jagade bubi no bubi. For example, Tawang, disputed area de utusai fani na jabe residents. Na aro profession, kumba profession no bubi, singer no bubi go pare, artist no. They can do anything. Okay, in times of national emergency, utuko ase. They can go against Article 19, but only at times of war or external aggression. No, to power, do you guys think that it's necessary? I think that it's necessary. Okay, war time dedo public khan la kota kota huni thaibo nage. There will be a certain group of people China takki support kora manon thaibo. Ta la kota huni thaibo nage na. India manu murshe mon bi pachile, but people in power, let them do it, let them fight. We give them the entire power as long as mon ge namara takto zinda thaga takto phat khaw bare gule do usido inya time dedo. So that's it. Article 359, suspension of rights to constitutional remedies. Very interesting, okay? Right to constitutional remedies, Article 32. Now, Mohan, by chance, in case our fundamental right is violated, we can go to the Supreme Court to enforce the writs. Habeas corpus mandamus, certiorari. Do you guys remember? Governdo. Yes. Udo constitutional remedies to use corona parogase. Key situation to Supreme Court the President may suspend the right to move any court for the enforcement of specified fundamental rights during a national emergency. National emergency and there though fundamental rights are not suspended, okay? Your rights are not suspended. Only your right to approach the court for its enforcement is suspended. Now after a national emergency you can. Court public right to freedom of speech and expression freedom of press na one chamla avoid right to approach the court for their enforcement suspend. Okay, only Article 32. Now rights that cannot be suspended after the 44th Amendment, Constitutional Amendment, the rights guaranteed under Article 28. What is Article 28? Do you guys remember? Protection in respect of conviction for offences. Protection in respect of conviction for offences and protection of life and personal liberty. Protection of life, right? Freedom to go abroad. Manika Kandi was Union of India, Kesimo mentioned freedom of press. Protection of life and personal liberty. And then protection in respect of conviction for offences. I gave you guys 3 conditions. No ex post facto law, no double jeopardy, and no self-incrimination, which means no double jeopardy means no person can be punished for the same offense twice. Okay, with the right though, it will always be there. No self-incrimination though, no person shall be compelled to stand as a witness against himself. Now, no ex post facto law means a person should be punished only according to the law that existed at the time of the commission of the act. Like crime korala time de law the key tabisha udui chulawa. For example, 2026 you killed a man, and udu manu murade 20 years last sentence ase. Na, will be 2026 life jail ase. Will be amni ke 2016 morala tin da law ke as na udui chulawa ina time last. So utuan. And this can never be suspended even during a national emergency. Okay. Now Article 358 versus Article 359 automatically suspends Article 19. Article 359 suspends the right to move courts. Article 358 to Article 19 suspend grid. I've mentioned about that, but only in case of war or external aggression, and Article 359 it suspends Article 32 of the Indian Constitution, right to move the courts. Now here we have financial emergency. Okay, state emergency bujiche, national emergency bujiche. We will learn about financial emergency. Okay, the President may proclaim a financial emergency if he is satisfied that the financial stability or credit of India or any part of his territory is threatened. Now, it's very easy to understand. Serious financial crisis, threat to the country's creditworthiness, economic instability. Okay, but this must be approved by both houses of the parliament within 2 months by a simple majority. National emergency karne ekla special majority lagi de. Both for state emergency as well as for financial emergency, simple majority is enough. Simple majority. Okay. Now, effects of financial emergency. During a financial emergency, the Union may direct the states to observe specified financial principles, reduce government expenditure, reserve money bills for the President's consideration. The President may also direct reduction in the salaries and allowances of Union and state government employees, reduction in the salaries of judges of Supreme Court and High Court. Buchi ase do everything about money. All of mala salary bi kumdi kurole chance ase. Now financial emergency time there. No important fact, no financial emergency has ever been proclaimed in India so far. Okay, no financial emergency has ever been proclaimed in India. So please take a look at it. Comparative analysis. Article 352 to Article 360. That's all you need. Okay, that's all you need. It contains everything, almost everything. Is that clear? The entire country, president's rule do state laws, financial emergency do puisa laws, it has never been declared. Okay, so president's rule time do particular state, one single state as a failure of constitutional machinery. Underground garne mon president's rule do declare gona pro. A lot of people have this misconception that president's rule was imposed during the 1980s, 1970s because of the insurgency issue. No, it's not directly because of the insurgency issue, but the insurgency issue made the state government unable to protect its people, unable to enforce the constitution. So it became a constitutional failure of constitutional machinery, by virtue of which the president's rule was imposed. Okay, not necessarily because of the existence of insurgency. Insurgency, if the state government has the power to control that, president's rule not about it. But Mala state government though, it has the power to control the insurgents, right now. It was there. Underground garne president's rule anyway. A lot of people say that it's a common misconception. Okay, and that's it. Yeah, the overall overview of the three emergencies. Okay, you have to memorize it. One is 352, one is 356, one is 360. Approval within 1 month for national emergencies. It requires special majority. Approval within 2 months. Simple majority for state and national emergency. Very simple. And maximum limit to 3 years. Only for state emergency, president's rule. Okay. Baki tuita to maximum specified corona nai. But it is renewable every 6 months. And financial emergency la are renewable that we mentioned corona nai. Okay. So I mentioned earlier about 38, 42nd, and 44th Amendment. Okay, you can read about that when the time comes. Now 1975. Now anything during 1975, Indira Gandhi la time dia jago bide. Indira Gandhi aro intention me bisi biya la intention la laws khani thaisu da de. 1975 the president's satisfaction made final whenever an emergency was declared. It was not too subject to judicial review. Okay, president's satisfaction, president's decision to declare emergency is final. Ko ase, 38th Amendment Indira Gandhi by approved call ase. So that question no prove Supreme Court probably kun probably na, but it was struck down later by judicial review. The Supreme Court made a declaration. Okay, and 42nd Amendment is strengthened the powers of the Union during the emergency. There are some few features not too important for exam. But you have to know which amendment strengthened the powers of the Union during the emergency. And 44th Amendment, it replaced internal disturbance with armed rebellion. Again, Indira Gandhi time de internal disturbance ko ina do India pura ge national emergency dai declare gushe. Ekta dictatorship la face ekta thakise, which is why they had to change it. Okay, and also protection of Article 20 and 21. It was also derived from 44th Amendment. Okay, and so forth. So you can research on this once you guys go back home. So this is Article 18 summary. National emergency. Yeah. So that's it. I think we have covered everything. Suspension of Article 19. I hope all of you remember. It's only for national emergency in case of war or external aggression. Okay, Article 19. Now we will look at miscellaneous. We have just 6 or 7 slides. Let's cover that for today. Miscellaneous. Day, one by one we'll go through it. Miscellaneous means like there's no specific chapter, there's no specific topic. Side alag topic kan ekta jaga de jama garna thakala ase. Deals with immunities of constitutional authorities like the president, the governor, tahala immunity. Court cases cannot be the civil cases or criminal cases can la rules can ase for the governor and the president. We'll discuss about that. Preview process historical ase the annual payment given to the prince, the head of the princely states. Raja Khan gana first the integration of princely states. 552 princely states the kota guristo. I guess I told you guys, Vallabhbhai Patel, which is why he's known as the Iron Man of India, for his integration of 552 princely states. Udo tangi promise ko siya, to angi pusa man diwo every year India joined group and all that. So privy purse was removed in the 1970s. I mentioned a few days back. So recognition of major ports and airport for importance, interpretation of constitutional terms. Okay, miscellaneous. Now protection of president and governors is mentioned here. They are not answerable to any court for the exercise of their official powers and duties. Okay, that's the first point. They are not answerable to any court for the exercise of their official powers and duties. No criminal proceedings shall be instituted against governor or president though if he has committed a crime. Tala governorship there, no criminal proceedings shall be instituted. Case lagaw na pre. Only after he steps down from the post of the governor, criminal proceedings can be instituted, continued against them. Okay, they cannot also be arrested or imprisoned while in office. Office sagaram day, the governor cannot be arrested, the governor cannot be imprisoned. Okay, now civil proceedings. Civil proceedings may be initiated only after giving 2 months prior notice. Udo the governor office se thaganam day ase. Civil proceedings may be initiated only after giving 2 months prior notice and only for acts done in their personal capacity, not official capacity. Civil proceedings. Okay, so for civil cases, right? Civil cases could be tai pusa chor gurse, murgi chor gurse. Udon sob civil cases aise pusa chor gra. To civil proceedings are divorce and all that. Udon gurse na. Take the power divorce or whatever may be the case, any kind of civil case, it will be initiated only after giving 2 months prior notice. Mantak respect dia as governor or president, so you have to understand that. And purpose to ensure the independence and dignified functioning of the highest constitutional office of the president and the governor. Okay, so criminal case to tan governorship or presidentship la time bit corona bro, but civil case can be done, but only with 2 months prior notice. Okay. Now Article 361A, protection of publication of proceedings. No person shall be liable for publishing a substantially true report of the proceedings of the Parliament and state legislature. Now just see, it gives protection to the press. Okay, the press. If you're a journalist and then us publics, we don't have the time to attend the parliamentary meetings. Nah? One hour meetings, and we don't also have time to analyze what went down, all the discussions that were conducted. But the journalists, they go inside, they record the videos, and then based on the videos, or they watch the videos, and then they provide us with a comparative analysis of what this minister promised, what this thing said. So it protects them. Okay, it says that no person shall be liable for publishing a substantially true report of the proceedings of the Parliament. Substantially true report, meaning they can paraphrase it, they can modify it, but as long as the point is makes sense. If they modify it a little bit, substantially true report, as long as it's a substantially true report, that person will not be punished. Okay, so which means ekta transparency. Tanki discuss also the transparency kawale na, ekta the protection to diya se to the journalists and the press. This protection does not apply to secret sittings, which means secret kota goradam do phone tap kurigna record khan gurina udu kalti ase. Secret meetings are proceedings specifically prohibited from publication. Okay, so bujas na udu part na disqualification on grounds of defection. Now very interesting point, okay? A member disqualified under the then schedule anti-defection law shall also be disqualified from being appointed as a minister or holding any remunerated political office until the term of the legislature expires or the member is re-elected. Now, what does this mean? Then schedule the anti-defection law in India. So if you defect from, let's say, Congress, and then you defect to BJP, now, तो अपनी ला seat तो अपनी disqualify हो जाओ. You're a member of parliament, Superman got elected with the Congress ticket, okay? And if he defects to BJP, he will be disqualified. That's the condition, he will be disqualified. So, from being appointed as a minister or holding any remunerated political post. So, he will not only be disqualified from being a minister, okay, but he is not allowed to hold any office. कुनबा तो थाके तो disqualify की करने हुए. For example, मोदी जी बस सुबह मॉर्निंग कुछ है ना, आपने यदि बात जावे आपने की disqualify करो, हिलो भी आपने की तंगों पोस्ट एक ताकि वो नीति आयोग ला वाइस चेयरपर्सन दियो, सुबह मॉर्निंग नहीं छाड़ दियो तो ना, and then BJP ते आई जाओ तो इतो नहीं कुछ है, ताई लगा legislature, ताई लगा term complete नहा तक तो ताई की ऑफिस भी चलाओ ना पड़ो, अलग ते भी जाओ ना पड़ो, ना और ताई re-election time दे re-elect खुशी के लिए तो नतुन आसे, बोले भी ताला term expire नहा तक तो ताई भी अलग ऑफिस hold करो ना पड़ो, कुछ ऐसा ना. So that's the only explanation in Article 361p. Article 362, rights and privileges of rulers of Indian states. Rights and privileges of rulers of Indian states. Please, you do not need to know that because these are rights. It states that rights and privileges should be given to former rulers of princely states, okay? But it was removed by the 26th Constitutional Amendment Act of 1971. The abolition of privy purses, like I said, privy purses, annual payment made to the rulers of princely states, to be removed now by the 26th Constitutional Amendment of 1971. Now, power to interference by courts in certain disputes. Courts have no jurisdiction over disputes arising out of treaties, agreements, covenants, sanats, and similar instruments. Sanat means any kind of official agreement that the central government had with the princely rulers. Okay, it's a document, sanat. Na, so the same as it. The courts have no jurisdiction. Utu time there for the integration of princely states. Utu time there lagala there, but not that necessary. Which means, monki gurule se minister kan jagina princely states kan lot khota kures na. So ye court interfere no probi itu ko ase. Because kunba kan do by force pi law las do mon. Na by force by police action ba bi law las e. All of kita ba the force aggression bi chala lage to. तो थामादम उतु टाइम दे पिछे सेंसिटिव टाइम दे जे तो कोर्ट इंटरफेयर न करबे कोना कॉन्स्टिट्यूशन दे दिया लाजे उतु एस दे इदा द इमान रेलेवेंस नाइ आर्टिकल 363A. Okay, this is the last fourth slide. Recognition of rulers and abolition of privy purse. Now utu inserted by 26th Constitutional Amendment Act of 1971. I mentioned earlier that 26th Constitutional Amendment Act 1971 recognize our privy purse be stop condition na to utudo 363A as the article. Now article 364, special provisions for major ports and airports. Again, it's for major ports and airports. The president may issue directions to a state regarding matters connected with major ports and airports if such directions are considered necessary in the national interest. For example, let's look at the ports in Gujarat, Andhra Pradesh, the Visakhapatnam. If you guys have gone there, these are very important ports. Okay, it only states kanla under the eye, but yet they power diginase to the parliament to issue any direction to the state for these important ports and airports. Which is na. So yeah, that's it. And now Article 365 is very important. Okay, 365 is very important. Article 355 is related to Article 356, the President's Rule. And please don't miss out on this explanation, okay? Please read it. If a state fails to comply with the directions issued by the Union, in case Union bra ekta mon ge directive ekta dishe, and then mon bra follow koranai, then the president may hold that the government of the state cannot be carried on in accordance with the constitution. It will declare that, to Nagaland Legislative Assembly though, it cannot go on in accordance with the constitution. So, in that case, president's rule awo paruwa. Na, so Article 365 la condition bra Article 356 to invoke korigina president's rule awo paruwa de. This Article 365 is very important, very very important. It provides an important constitutional basis for the impossible invocation of Article 356, President's Rule. Okay, and Article 366, just give one word, dictionary. It's not mentioned again in the Constitution that it's a dictionary, but contains all the definitions of Indian Constitution. Okay, definitions of important constitutional terms such as Anglo-Indian ki ase, Corporation Tax ki ase, GST ki ase, ST, SC ki ase, sob digina ase. Yade Article 366. So if you wish to find out the terms of so and so, 366 jabe and you will find all the important terms. Okay. Article 367, it provides the general rules of interpretation of the Constitution. It states that the General Clauses Act 1897 applies to the interpretation of the Constitution unless the context otherwise requires. Now, General Clauses Act 1897 to British la time there as well. Other than the British they are masters of the English language, right? So they've given a very good rules of interpretation for the Constitution. What is the meaning of rule of law? How should it be interpreted? And this and that. Rules as it. The British Khanba Likina already Raki Diala. The rule July de Mo Ajida. We use this rule to interpret the Indian Constitution. Okay. Now this is the last slide. Part 19 summary. In the miscellaneous, we first looked at the immunities of the president and the governor, right? In terms of criminal cases, during his term of office, no criminal proceeding can be processed against him, but civil cases can be only with the condition that 2 months prior notice diwa lagi. And then publication of legislative proceedings, one parliament la meeting, state legislative assembly la meeting de publish journalists can publish krado. Yet protection as a journalist can get. They shall not be arrested. They shall not be punished for publication of legislative proceedings and disqualification of the defection. If he defected from Congress party to BJP party, amni alak government post eko hold grown up until the term ends. To discourage defection and the rights of former rulers, ita to natakaw siya, privy persons and so forth. And Article 363, part to court jurisdiction, uta time to be priestly says integrate kradam dito, court interfere no kuru vide equal as a. And then major ports and airports de, na India de kiman as a yede, parliament can instruct the state. And then 365, failure to comply with union directions. For example, tomorrow, if the union government instructs the Nagaland government to remove all the, what do we call that? They use a term, okay, underground skangala, tan like area of operation. Yede dimore thakakando. Ito pura hatay di na Oscar tuloy jabe na. State government ba comply grana bule do? The union government will consider that the state government is unable to function in accordance with the Indian Constitution, and therefore president's rule is necessary. Inala. So Article 366, definitions, the dictionary, like I mentioned, and Article 367, the interpretation, General Clauses Act 1897. Okay, interpretation of Indian Constitution. So I hope Article 19 is clear to all of you. If there's any doubt, please let me know.